Okay, students, Assalamu alaikum and welcome you all. Students, today is the 14th lecture and 14th week of our class, and we are now going to complete the third part of the this course, that is the examination of the witnesses. And we have already completed 154 articles of Qanun Shahadat at our course, and remaining two classes, inshallah, we will complete our remaining course and remaining article, because there are only 10 articles are remaining, and thereafter we will study and we will learn. And there are other some very much important sections, books, and laws regarding the law of evidence. So here is the students. I'm going to start my today's lecture. Start from where we have stopped in previous week. So here's the first article of today's lecture. I'm going to start my today's lecture from the article 155 of the Qanun-e-Shahadat Order 1984. Article 155 regarding the refreshing of the memory. In this article, there are four paragraphs, and I'm going to read out each one. Uh, Article 55, refreshing of memory, sub-article 1, which says that a witness may, while under examination, refresh his memory by referring to any writing made by himself at the time of the transaction concerning which he is questioned, or soon afterwards that the court considers it likely that the transaction was at that time fresh in his memory. Sub Article 2 of that article, the witness may also refer to any such writings made by any other person and read by the witness within the time aforesaid, if when he read it, he knew it to be correct. Sub-article 3 of that article says that whenever a witness may refresh his memory by reference to any document, he may, with the permission of the court, refer to a copy of such document. There's a one condition, provided that the court be satisfied that there is a sufficient reason of the non-production of the original. And sub-article 4 of above article, said article 155, an expert may refresh his memory by reference to the professional treatise. So that was the uh, statute, that was the language and contents of the article 155, which is consists of the four sub-articles, and I have read out for your convenience. And this article says how a witness may refresh his memory. He may, during his examination, refresh his memory by referring to, as per the article, three things. Number one, any writing made by himself, any writing which is made by that person or that witness at the time of the transaction concerning which he is questioned, or so soon afterwards that the court considered it likely that the transaction was fresh in his memory. 2. Any such writing made by any other person and read by the witness within the time aforesaid. 3. Professional treatise if the witness is an expert. So it is not necessary that the writing referred should be one which is admissible in evidence. A document not produced in the court within proper time and in the consequences rejected may be referred to refresh his memory if it comes within the purview of this section. Even if a panchanama, uh, charge sheet, challan containing a statement made by a witness as to the crime committed is not admissible in evidence, A witness can make use of it for the purpose of refreshing his memory. Where the challan or charge sheet is made by the police but is immediately read over to the Mashir and admitted by him to be correct. But a court should not take cognizance of such terms of the document which is inadmissible in evidence and has been referred to by a witness mainly or merely in order to refresh his memory as to a date. It is not necessary that the witness should have specific recollection of the facts themselves. The adverse party has a right of seeing the writing so used and cross-examine the witness thereupon. ये किसी जो एडवर्स पार्टी के काउंसिल का एडवोकेट का जो मुखालिफ का वकील होता है उसका राइट होता है जो डॉक्यूमेंट विटनेस रिफ्रेश करता है अपनी मेमोरी उसको रीड आउट करके या उसके कंटेंट्स के गॉन थ्रू करके तो फिर जो मुखालिफ वकील का राइट है कि फिर उस पर उसका क्रॉस एग्जामिन करे जो राइट जो है इसको वो आर्टिकल आगे जो है हम जाके इसको पढ़ेंगे 157 में प्रोवाइडेड है The grounds upon which the opposite party is permitted to inspect a writing used to refresh the memory of a witness are uh, वो तीन किस्म है जिस पे वो उसको अपोजिट पार्टी जो है उसको इजाजत दी जाती है इंस्पेक्शन की नंबर वन to secure the full benefit of the witness's recollection is to the whole of the facts. Number two, to check the use of the improper document and to compare his oral testimony with his written statement. And what about the copy of such document? The Act does not require that this copy shall have been made by the witness himself or in his presence or is to enable him to swear to its accuracy. A register which is not a secondary evidence of the contents of a bond may be referred to by a witness for the purpose of it. And what about thereafter the examination of the witnesses? The statements of the witnesses recorded after a lapse of nearly 3 years of the occurrence and the human memory being always short, witnesses had not expected to relate all the details with scientific precision. सो इट इज द ट्रुथ अगर कोई स्टेटमेंट्स किसी मुकदमे में या किसी केस में जो स्टेटमेंट्स हैज बीन रिकॉर्डेड सो अर्लियर एंड ट्रायल हैज बीन कंडक्टेड आफ्टर द लैप्स ऑफ प्रोलॉन्ग पीरियड तो उसके अगर उसको काफ़ी ड्रैग हो जाती है ट्रायल देर से कंडक्ट की जाती है और स्टेटमेंट जो है वो रिकॉर्ड हो चुकी होती हैं और वो क्योंकि एक हमारी ह्यूमन माइंड जो हमारा ह्यूमन ब्रेन है it is not capable the brain is not capable to keep the things for indefinite time तो वो फेट्स और वो जो मेमोरी पे जो चीज जो हमारे मेमोरी में जो चीज़ें होती हैं वक्त के साथ वो मेमोरी से लॉस हो जाती हैं तो इस प्रोविजन का भी यही मकसद है कि इस प्रोविजन की मदद से हम अपनी मेमोरी को रिफ्रेश कर सकते हैं regarding the older statements which is already on the record of the. What about the examination of the witnesses by the अगर कोई पुलिस केस अगर होगा तो पुलिस केस के साथ आपने मोस्टली पुलिस पेपर देखे होंगे जो कंसिस्ट करते हैं मोस्टली स्टेटमेंट्स डायरीज और प्रोग्रेस होती है पुलिस इन्वेस्टिगेशन की जो रिपोर्ट फाइल होती है तो उसकी जो एग्जामिनेशन ऑफ द विटनेसेस बाय पुलिस डायरी ऑफ द प्रोसीडिंग्स इन इन्वेस्टिगेशन रिलेवेंसी ऑफ द पब्लिक record made in performance of the duty, nature, refreshing of the memory, and what will be the procedure. The provision of the Section 161 of the Criminal Procedure Code is independent of the Section 172 of the Criminal Procedure Code. Only the case diaries are meant to be treated as a privilege and shall not be made accessible to the accused. Court, in terms of Article 15 Kanun Shahadat, can force the investigating officer to look into the case diaries to answer correctly the question put to him in cross-examination. Case diaries can also be used by the court to trace out the various stages of the investigation. Statements recorded under Section 161 CRPC are not privileges, even if recorded in the body of the case diaries. Such statements are public document within the meaning of the Article 49 of Qanun-e-Shahadat and are per se relevant under the said article. Privilege is stated in Section 172. Criminal Procedure Code is not of absolute nature, and provision of the Qanun-e-Shahadat are independent of the Criminal Procedure Code. अब जिस तरह पुलिस पेपर के साथ कुछ स्टेटमेंट्स होती हैं तो वो उनकी नेचर एज ए पब्लिक डॉक्यूमेंट जिस तरह कौन सी हम एक्सेस कर सकते हैं, तो बहुत सारी चीज़ें जो होती हैं वो क्यूज को नहीं प्रोवाइड की जाती उनको पुलिस पेपर के साथ स्टेटमेंट और चालान 162 161 वो जो भी नेचर होती है वो प्रोवाइड की जाती है, लेकिन 172 में जो डायरीज बनाती है पुलिस अपनी डेली रूटीन की जो जितनी भी कार्रवाई वो मेंशन करते हैं वो दीज आर नॉट सपोज टू प्रोवाइड द अक्यूज, लेकिन कोर्ट उसको ट्रेस आउट कर सकती है। डाइंग डिक्लेरेशन जो है डाइंग डिक्लेरेशन which is admissible under clause 1 of the article 46 of the Qanun-e-Shahadat is first to be proved that the same is genuine and true, and then it can be acted upon, and some sort of corroboration is also required. Method to prove the recording of the dying declaration is to examine the some persons who were present at the time and heard the statement being made, or if the statement was written or dictated by the deceased, it must be proved. If the said statement is not proved in the such manner, then it will be inadmissible, even though it may have been recorded by the magistrate under Article 91 of the Qanun-e-Shahadat, does not raise any presumption that the said statement was made by the particular person. When a person who recorded the dying declaration is called, he is required either to repeat what deceased had stated, refreshing memory from the record of under Article 155 Qanun-e-Shahadat, or to merely report that the record correctly represents what the deceased had stated. But in any case, the record must be brought and proved in accordance with the law. तो जो इस आर्टिकल का जो मेन मकसद व्हाट वी हैव लर्न दैट कि अर्लियर स्टेटमेंट जो कोर्ट के रिकॉर्ड में होती हैं, अब विटनेस कॉल होता है लेकिन विटनेस काफ़ी अरसे के बाद उसको कॉल किया जाता है, तो उसका राइट होता है कि जिसकी वो स्टेटमेंट दे रहा है तो उसकी वो उस डॉक्यूमेंट से उस रिकॉर्ड से जो कोर्ट में है तो वो उससे अपनी मेमोरी जो है वो रिफ्रेश जो है वो कर सकता है। तो ये एक टूल है या एक एडमिसिबल का एक हमारे पास ट्रायल के दौरान कानून में इजाज़त है कि ये नहीं हो सकता कि हमें कोई रोक इस रिकॉर्ड के एक्सेस से मुखालिफ जो है वो मना कर सके, क्योंकि वो हमें जो है इसकी परमिशन है कि जो रिकॉर्ड जो डॉक्यूमेंट्स हैं या कोई कंटेंट्स हैं या कोई स्टेटमेंट है तो जिस पे कोई क्रॉस एग्जामिनेशन होने जा रहा है तो उसको या किसकी स्टेटमेंट हम रिकॉर्ड कराने जा रहे हैं तो उसके लिए हम उसकी अपनी मेमोरी रिफ्रेश कर सकते हैं, कोर्ट हमें टाइम दे सकती है। तो स्टूडेंट फर्दर जो नेक्स्ट आर्टिकल है वो ये आर्टिकल भी रिलेटेड है प्रीवियस आर्टिकल से, टेस्टिमनी टू फैक्ट्स स्टेटेड इन डॉक्यूमेंट मेंशन इन आर्टिकल 155. A witness may also testify to facts mentioned in any such document as is mentioned in Article 155, although he has no specific recollection of the facts themselves, if he is sure that the facts were correctly recorded in the document. That is the Article 156, which means जो उसको further जो है समझने के लिए, in order to understand fully that article, there is an illustration also provided. It means that there's a bookkeeper may testify to facts recorded by him in books regularly kept in the course of the business. If he knows that the books were correctly kept, although he has forgot the particular transaction entered. The principle of the above or foregoing article is carried a step further here. A witness may refresh his memory by document, even though he has no specific recollection of the facts themselves, but he must be sure that the facts were correctly recorded in the document. If the witness had not correctly recorded the words used by the speaker, but only his impression, then the notes made by him would be inadmissible to prove the words used. The article applies, the reason of that article is that when the witness stated in so many words that he does not recollect, and when the circumstances establish beyond doubt that this is so, having no specific recollection of the facts, he can only testify regarding the contents of the document before him and claim that he recorded correctly what the deponent said at that time. And then that a document may be used as the refresher of the memory. It is by no means necessary that the witness, after having seen it, should have an independent recollection of the facts mentioned therein or connected therewith. It will suffice if he remembers that the that he has seen the paper before and that when he saw it, he knew its contents to be correct, or even if entirely forgetting the circumstances themselves and the fact of his having seen the paper, he can still, in consequences of the recognizing his signature of the writing upon it, vouch of the accuracy of the memorandum or swear to the particular fact in the question. This article is related with the facts which are mentioned, which are incorporated in document that can also be refreshed. This article 155 also help कि any record which keeps in a book, जिस तरह कोई एक रिकॉर्ड कीपर होता है या अकाउंट्स कोई जो है वो बनाता है, तो किसी भी अकाउंट्स के या किसी भी रजिस्टर का या किसी भी रिकॉर्ड का अगर वो बुक कीपर है और उसके सामने वो चीज़ें इनकॉपरेट की जाती हैं, बहुत पुरानी या बल्कि हैं, इन वॉल्यूम्स हैं, तो सर्कमस्टेंसेस तो मोस्टली नहीं याद होते, ठीक है ना, लेकिन उसको ये मेमोराइज कर सकता है या ये फिक्स कर सकता है कि सर्कमस्टेंसेस तो याद नहीं है लेकिन इसको ये याद है कि ये इसके सामने इस तरह ये एंट्री की गई, तो दैट इज द इनफ जो मेन इस आर्टिकल का जो मकसद है. Thereafter, the next article 157 right of the adverse party as to writing used to refresh the memory. अब this article जिस तरह पहले बताया था, I earlier said कि empower the right of the adverse party. Any writing referred to under the provisions of the two last preceding articles must be produced and shown to the adverse party if he requires it. Such party may, if he pleases, क्रॉस एग्जामिन द विटनेस देयरअपॉन. या कोई भी राइटिंग हो या कोई भी स्टेटमेंट अगर कोई विटनेस ख्वाहिश करता है अपनी मेमोरी रिफ्रेश करने के लिए, तो उससे पहले वो मुखालिफ के वकील को या मुखालिफ पार्टी को वो दिखाया जाता है कि उसको क्या दिखाया जाता है, उसको कौन से कंटेंट्स जो है वो रिफ्रेश करना चाह रहा है, तो जिस पे फिर वो मुखालिफ जो है उससे क्रॉस एग्जामिन कर सकता है. तो जो इस आर्टिकल का जो मेन मकसद है कि अपोजिट पार्टी है राइट ऑफ inspecting document used in the court for the purpose of the refreshing of the memory of the witnesses. तो ये इस आर्टिकल का मकसद है. इस आर्टिकल ये आर्टिकल मुखालिफ को अपना राइट देता है, प्रोटेक्शन देता है, वक्त उसको देता है कि वो देख सकता है कि जो कानून ने एक हेल्प दी है किसी विटनेस को, तो उसको पता होना चाहिए कि वो क्या कोर्ट क्या कर रही है और क्यों कर रही है, फिर उसको पे अपना राइट महफूज करने का भी हक है कि फिर वो उसे क्रॉस एग्जामिन करे या ना करे, फिर ये उसका अपना प्रोरोगेटिव जो है वो राइट है कि उसको यूज कर सकता है. अगर नहीं करना चाहे तो फिर वो राइट उसका वेव भी हो जाता है. उसके बाद जो नेक्स्ट आर्टिकल है स्टूडेंट्स वो है प्रोटेक्शन ऑफ द डॉक्यूमेंट्स 158. इस आर्टिकल के तकरीबन 3 सब आर्टिकल्स हैं. सबसे पहले एज यूजुअल मैं पूरा आर्टिकल पढ़ लेता हूँ, उधर फिर इसको जो है फिर मैं इसकी इंटरप्रिटेशन आपको दूंगा. तो 158 आर्टिकल जो कानून शहादत है वो प्रोटेक्शन ऑफ द डॉक्यूमेंट्स है. इसका जो सब आर्टिकल 1 है, अ विटनेस समन टू प्रोड्यूस अ डॉक्यूमेंट शैल, if it is in his possession or power, bring to it court notwithstanding any objection which there may be to its protection or to its admissibility. The validity of any objection shall be decided on by the court. Subarticle 2 of the same article, the court, if it sees fit, may inspect the document unless it refers to the matters of the state or make evidence to enable it to determine on its admissibility. Thereafter, जो सब article 3 है students of the same article, if for such purpose it is necessary to cause any document to be translated, the court may, if it thinks fit, direct the translator to keep the contents secret unless the document is to be given in evidence, and if the translator disobeys such direction, he shall be held to have committed an offence under the section 166 of the Pakistan Penal Code. So ये एक penal आखिरी जो सब आर्टिकल 3 है, that is the penal clause. एनी वायलेशन, अगर किसी कोर्ट की डायरेक्शन की वायलेशन होती है तो फिर ये इसकी जो नेचर है ये दैट द पेनल क्लॉज. अब इस आर्टिकल का मेन प्रिंसिपल क्या है? Under this article, the validity of an objection to the production of the document has to be determined by the court. The only limitation on the power of the court is that cases of the documents where privileges is claimed under Article 6 of the court may not look at those documents but must determine the validity of the claim on the material other than the document itself. When a witness is summoned to produce a document which is in his possession or power, he must bring it to the court. Therefore, any objection that he may have with that regard to its production or admissibility, the, under the provision of Ordinance 16 Rule 6 of the सिविल प्रोसीजर कोड, जो डॉक्यूमेंट्स जो प्रोटेक्शन के या डॉक्यूमेंट्स के एग्जामिन के जो रिलेटेड प्रोविजन है वो कोड ऑफ सिविल प्रोसीजर में मौजूद हैं, कोड ऑफ क्रिमिनल प्रोसीजर में भी मौजूद हैं. ये जो एक इंडिपेंडेंट क्योंकि कोड है तो इसमें 151 हेल्पफुल है कि कोई भी डॉक्यूमेंट हम कॉल कर सकते हैं अगर हमारे को पावर या हमारे इंस्पेक्शन में नहीं है. हमें पता है कि किसके पास है तो उसके कॉल करके उसको नोटिस भिजवा के तो इस प्रोविजन के तहत उसको हम कॉल करा सकते हैं. A person may be summoned to produce a document without being summoned to give evidence. He may either attend the court personally or may depute any other to produce it. In neither case is he liable to be cross-examined as per the Article 134. Earlier we have studied. If the document be in his possession or power, he is bound under this article to bring the document with him to court. Therefore, any objection he may have to its protection, that is the Article 13 or 14, or Article 9 or 12, or admissibility, as per those articles of the same code, Kanun-e-Shahadat, as we have earlier studied, these are regarding the privileges of anything. If any document come in that ambit, so court will consider it and will look it, and having brought it to the court, he is entitled to raise his objection to its protection or admissibility. The court has then to decide the validity of any such objection for the purpose of deciding on the validity of the reason that may be offered for withholding them. The court may receive evidence and in so doing it is entitled to inspect or the document if it does not refer to matters of the state as per the article 6 of this code. If the document in question happens to be in a language not known to the presiding officer, he may get it translated and call upon the translator to keep its content secret. And the subject matter challenge and the constitution petition to which the provisional government was a party. The provisional government in its comments in the constitution relied on certain document, not nothing whatsoever indicated the possibility of any injury to any appreciable interest of the state or institution by protection of the document. Power of the court to send for such document for the examination, which in its opinion was necessary for the just decision for the case. So, how privilege will decide the order of the special court claim of the privilege without examining the material in respect of which such privilege was claimed was set aside. So, court is directed to consider question of the privilege in the light of the facts enumerated. So this article, students, we have studied regarding the production of the document which is not power or inspection under the party who is calling it, and the document which is lying or in custody of another party. So court will issue the notice and mention the list of documents which are required to produce before the court. So in order to correlated provisions, statutes also you have studied in the code of civil procedure and as well as criminal procedure code, which are very much relevant procedures, relevant provisions regarding the protection of the document. जिस तरह के कोड ऑफ सिविल प्रोसीजर में ऑर्डर 11 है, that is also regarding the प्रोटेक्शन और एग्जामिनेशन ऑफ डॉक्यूमेंट, और ऑर्डर 12 जो है जिस तरह ऑर्डर ऑर्डर 11 है इंट्रोगेटरीज और एडमिशन ऑफ एनी डॉक्यूमेंट इफ मेंशन, तो ऑर्डर 12 भी हेल्पफुल है। उसके अलावा फिर ऑर्डर 13 है, ऑर्डर 4 जो है ऑर्डर 16 है, और ऑर्डर 7 रूल 14 भी जो है वो रूल 11 या 14 जो है, that is also regarding the calling of the person who produced the document which is custody lying in the custody of the opposite party. So thereafter it's related ये core article है giving as evidence of the document called for and produce on notice. अगर कोर्ट कोई नोटिस इशू करती है किसी भी पर्सन को कि वो आके कोर्ट में कोई सर्टेन डॉक्यूमेंट प्रोड्यूस करे, तो उसकी एविडेंस और अगर नहीं करता तो फिर उसके जो है कॉन्सिक्वेंसेस क्या होंगे, वो आगे दो आर्टिकल विच आर रिलेटेड विद द आर्टिकल 158 जो है। जिस तरह ये आर्टिकल है कि व्हेन अ पार्टी कॉल्स फॉर अ डॉक्यूमेंट व्हिच ही हैज गिवन द अदर पार्टी नोटिस टू प्रोड्यूस and such document is produced and inspected by the party calling for its protection, he is bound to give it as evidence if the party producing it require him to do so. So the principle of this article, which I have read in order to understand you, कि ये आर्टिकल के जो कंटेंट्स थे वो मैंने अभी पढ़े हैं, तो उसके प्रिंसिपल जो है, व्हेन अ पार्टी टू अ सूट गिव्स नोटिस टू द अदर पार्टी टू प्रोड्यूस अ डॉक्यूमेंट एंड व्हेन प्रोड्यूस the inspection or he inspects the same, the person is bound to give it as evidence if the other party requires him to do so. The reason for this rule is that it would give an unconscionable advantages to a party to enable him to uh, enable him to the affairs of his adversary without at the same time subjecting him to the risks of making whatever he inspects evidence for both the parties. The party is bound to give the opponent's documents as evidence in this case. There are three conditions which has to be fulfilled. Number one, the document should be required by that party to be produced in evidence. अगर कोई भी डॉक्यूमेंट आप किसी भी केस में कॉल करते हैं, इट मस्ट बी जो है उसको केस में आप प्रोड्यूस करेंगे. इट शुड बी इंस्पेक्टेड बाय द पार्टी कॉलिंग फॉर इट्स प्रोटेक्शन. द पार्टी प्रोड्यूसिंग द डॉक्यूमेंट शुड रिक्वायर द पार्टी कॉलिंग फॉर इट टू पुट इन एविडेंस. तो वो उसके लिए लाजमी है कि वो उसको उस केस में, उस ट्रायल में उससे उसको रिलेट करे या उसके साथ उसको शामिल करे. तो इस आर्टिकल का जो फिर स्कोप होगा, द आर्टिकल इज एप्लीकेबल टू क्रिमिनल ट्राइल्स एज वेल एज बोथ सिविल एक्शंस. Records of statements made not on oath in the course of the departmental inquiry by the government are not public documents. But when the defense had called for their protection and they were thereupon produced and inspected and used for the cross examination of the prosecution witnesses, it was held that it was had that the code could insist on the entire statements being put in under this article. जब किसी भी पार्टी को बुलाया जाता है in order to produce a document, the terms of the article make it clear that the article refers to the document asked for by a party during trial. It does not refer document produced under order 12 rule 14 of the code of अगर ये प्रोविजन आप अप्लाई करते हैं इन ऑर्डर ड्यूरिंग द कोर्स ऑफ लिटिगेशन, ड्यूरिंग द कोर्स ऑफ ट्रायल, अगर इस आर्टिकल को आप अप्लाई करेंगे तो ये जो भी डॉक्यूमेंट्स आप इसमें कॉल करेंगे, इट इज़ नेसेसरी दैट कि वो डॉक्यूमेंट की जो रिक्वायरमेंट ऑर्डर 12 या ऑर्डर 11 या दूसरे कोड में आप ऑलरेडी मेंशन कर चुके हैं, तो फिर ये अप्लाई नहीं होगा। और उसके साथ दूसरा जो आर्टिकल से रिलेटेड है 160, यूजिंग एज एविडेंस ऑफ द डॉक्यूमेंट प्रोडक्शन ऑफ द व्हिच वाज रेफर्ड ऑन नोटिस। When a party refuses to produce a document which he has had notice to produce, he cannot afterwards use the document as evidence without the consent of other party or order of the court. For example, अगर नोटिस इशू किया जाता है फॉर द इन ऑर्डर टू प्रोड्यूस सच डॉक्यूमेंट, अगर जिसको कहा जाता है वो रिफ्यूज करता है कि वो आगे कोर्ट में ये प्ली लेता है कि दोज डॉक्यूमेंट्स आर नॉट लाइंग अंडर माय कस्टडी, आई डोंट नो, वो एक जो है पोजीशन ऐसी लेता है जिसमें वो रिलेंटेड होता है और वो रिफ्यूज करता है। लेकिन देर आफ्टर फिर ये क्लियर आर्टिकल क्लियरली जो है फिर उस पर्सन को बाउंड करता है कि दिस दैट पर्सन विल नॉट देयर आफ्टरवर्ड्स प्रोड्यूस एनी सच डॉक्यूमेंट्स हु उसने उस वक्त उसको रिफ्यूज किया पेश करने से और उससे डिनाई किया कि उसकी कस्टडी से, तो वो दो शर्तों पे तो उसको कर सकता है, या जिस पार्टी ने उसको कॉल किया हो या उसके कंसेंट से या कोर्ट के डायरेक्शन से तो कर सकता है, अदरवाइज या कोर्ट की परमिशन से तो कर सकता है, अदरवाइज दैट पर्सन के नॉट यूज जो है उसके जो प्रिंसिपल है इस आर्टिकल का। इफ अ पार्टी हैविंग अ डॉक्यूमेंट इन हिज पोजीशन रिफ्यूजेस टू प्रोड्यूस इट व्हेन कॉल्ड अपॉन एट द हेयरिंग टू, he is not at liberty afterwards to give the document in evidence for any purpose without the consent of the other party or the order of the court. This is meant as a penalty for the unfair tactics. The civil code जिसमें यही सेम जो प्रोविजन है ये एक सिमिलर सिविल प्रोसीजर कोड में भी है, ऑर्डर 11 रूल 15 में make a similar provision. This article does not contemplate the production of a document for inspection. It contemplates that one party should call upon another in a court to produce a document of which the first party has given the other notice to produce. It does not give him any right at any stage of the case to call upon his opponent to produce the document and after respecting it to use it or not as he sees fit. It is doubtful if this article applies to the criminal procedure. तो ये तो आर्टिकल्स थे स्टूडेंट्स रिगार्ड जो तीन आर्टिकल्स 158, 159 और 160 रिगार्डिंग दी प्रोटेक्शन ऑफ द डॉक्यूमेंट देयर आफ्टर द इफेक्ट ऑफ दिस आर्टिकल, हाउ इट विल अप्लाई, जो इसकी एप्लीकेशन किस तरह की जाएगी। इससे पहले हमने जो रिफ्रेशिंग ऑफ मेमोरीज पढ़ा था उससे भी रिलेटेड तीन आर्टिकल थे 155, 156 एंड 157 व्हिच वी हैव स्टडी। नाउ जो फर्दर रिमेनिंग आज के जो लेक्चर के रिमेनिंग स्टूडेंट तीन आर्टिकल हैं